There we go. Welcome to WLJA Common Law Under God. I am Luciana, and I am here with Catherine Hine, who is a former Ohio attorney of 40 years who resigned in 2019. Hi, Catherine. How are you doing? Oh, I can't hear you. Catherine, I can't hear you. Hmm. Okay, just give us one moment. We'll get it going.
Now can you hear me?
Okay, sorry about that. Okay,
right,
how are
can
you
you hear me
doing? How
now?
you doing, Catherine?
I'm good. Can you hear me now?
I can hear you now. How are you?
Okay. Are you good? All right. Uh, okay. I think we have the name of the broadcast today, and there's a certain method that we're using. I'm trying to kind of write the broadcast in order
Oh,
so that really look at the first one.
okay,
Okay,
Catherine,
Catherine,
you're breaking up a little bit. Um, I don't.
is this any better?
Okay, try now.
Is this better?
I think so. We'll keep trying.
Okay. All right. I was just saying, this is our second broadcast on common law, and the first one we were addressing, the fact that we're going to be looking at conclusions, and I think we talked about the our status, correct?
Mhm. Right,
Last time, didn't we?
right,
Okay. Because you can't do much of anything unless you've corrected your status.
right.
So we hope to move right along, and unless you think there's something, preliminarily we ought to do before that, but I want to get into what the three notice process is
Correct.
and the fact it works, why it works, and and uh, and of course you don't do the three notice process until you've already corrected your status. In other words, you have already rebutted the presumptions that the de factos, the corporate players make about you being one of their slaves. You have to correct that first. Can you hear me okay?
Yes, much
Yes, much
better.
better.
Yeah.
Okay. Yeah. Um, and I don't know that we went into detail about that other than we referred people to our common law court website, which is www.occr2021.com. And, we can pull that up and, show you where others have corrected their status. If you go to the website and you look at status documents, you'll see what other people have done. And there's almost, it seems like, an infinite number of status documents that you can do, status corrections, because we're always signing our name to something and we're agreeing to be their slaves. We don't know that, because it's all, our signatures are induced by fraud, but we have to call them on the fraud in writing the same way that we entered into the fraud, which was in writing, and it was oftentimes under oath. So, yeah, okay, Luciana, you're bringing up, which one is that?
The notice and oath revoking citizenship in the corporate entity known as the United States and notice of rebuttal of presumptions created by birth registration sent sent to Anthony Blinken, um, uh, uh, holder of the corporate office known as Secretary of State of the United States in Washington, and to Frank LaRose, uh, Secretary of State in Columbus, Ohio.
Right, right. It's important to know that whenever we do notices, because common law is about people. Just remember, common law is always about people. We don't recognize attorneys, we don't recognize corporations. So when we address them in their offices. We don't send to their titles. We don't send to their corporate their corporate names. We send to the people who are running those operations, because that's what people do. People have always only interacted with other people, not with their imaginary friends that they call corporations, or they call other things. They usually don't like to admit that they're corporations. But I thought that we kind of covered that the last time.
Right. Yeah, we went through this.
Okay, so I just wanted to kind of connect this broadcast up with the first one that we did last week.
Okay.
So once you've corrected your status, and you've rescinded your voter registration, and you've repudiated the presumption that you're a corporate United States citizen, which you couldn't be anyway, because corporations don't have citizens. Corporations don't exist, actually, so they can't have citizens. And then the rebuttal of the presumptions created by the birth certificate they created to use using a distortion of your name. So once you've corrected all that, then you're in a position to actually get down to business and start the 3-notice process. Now, usually people find themselves in positions where they are either playing offense or defense. And most of the time we've been playing defense. And it's hard you can not be, injured too badly if you're playing defense successfully, but you don't gain anything until you go on offense. But you have to get yourself off defense first. And that's what the notice of the absence of subject matter jurisdiction does for us when we're dragged into one of their fake corporate tribunals they call courts. They don't have any subject matter jurisdiction. We have to notify them of that. Now, a lot of you are probably thinking, well, but I've done that. I've gone into their fake tribunals, and I have filed a motion to dismiss for lack of absence of subject matter jurisdiction, and it didn't work. Nothing works when you're first of all not free. You have not done your status documents, and you go into their tribunals. And I don't care if you've been threatened. We will arrest you if you don't. You go in there, you're still agreeing, okay, you're the boss, I'm the slave. As soon as you do that, nothing you do matters. So what we have to do is do everything, instead of submitting ourselves to their fake corporate rigmarole that they conduct in the public courthouse. We've dragged them into our world, the world of living people. And every single one of them, even though they've got all these titles, honorable this and judge that and attorney this and all those titles, they're still just people. So we address them as people, and we bring them into our world where our rules apply. And those rules are the rules of God that he gave us. And the best approximation of those rules have come to be called common law, which is basically whatever the people say the common law is. This is admitted by the so-called United States Supreme Court, that the people are the source of all law, all earthly law, God being the source of all law. But we're just here, to accept God's directive to us in Genesis 1:26. I'm going to give you this planet and all its creation, and you are to be stewards of that creation. And we have not been doing that. So this is how we do it. And actually, in the New Testament, Jesus speaks specifically about a 3-notice kind of process for any dispute you have with your fellow man or woman, of course. And every single time they drag you into their fake tribunals, what's really going on is there are a bunch of people running those tribunals, and your dispute was with the people, not with this silly creation, this corporate creation. You know, that creation, that corporation didn't do anything to us. It can't do anything to us, but the people
Exactly.
can. So anyway, so back to offense and defense. When you are when you are dragged into one of their fake tribunals, you are on defense, and you have to get out of defense as quick as you can, and that is through the 3 notice process. You don't let them decide anything, because they aren't the deciders. We, the people, are the deciders, and we have been shirking that role. And so I think their rationale is, well, we had to take on the role. You wouldn't. So we need to take our responsibilities back, because they aren't doing a very good job of taking on those responsibilities that rightfully belong to us in the first place. So what do? There's a first notice, and you, if you go to our website, you can see people have used those as well. And let's see. First of all, what do you do in a first notice? And the first notice is the most important one. You just say, here I am, I'm the claimant. Words are important things. I'm the claimant, and you guys who are doing whatever you're doing to me have harmed me. And we called them the respondents. I'm a living man or woman. The respondents are living men and women, no matter how many titles they have behind their names or in front of their names. They're still just people. And you tell them, you have harmed me in this way. And this is what you did. On such and such a day, you put in the who, the when, the what, the where, the how, not the why, because we may not know the why. But you put the other details in there, facts, just facts, preferably in short statements. And you know, you're a fallible man or woman. You know, you might be wrong on some of those facts. Try not to be, because you're going to be swearing that they're correct. And you invite them, you know, if you disagree, you have X number of days to disagree. It's that simple. And if you don't disagree, then you and they're notified about this too. If you don't send a response in, an adequate response, not just, oh, you guys are full of crap. That's not a response, and we define what a response is.
Yeah, we've gotten a response before from one of the attorneys, and it merely stated, don't send me this anymore. And what did he say? He said, this is not a thing.
This is not a legal thing.
He said, this is not a legal thing.
Yeah. However, the notice invited him to dispute the facts, and he didn't do that. So he didn't respond. And we define in our notice what, and they do this all the time. If you ever looked at the fine print on the back of your credit card bill, they give all kinds of details about who is who and what's what and what the rules are and all that. And they expect that if you continue to use the card, you know, by your conduct, you've agreed. Okay? So that's all we're doing. You know, we put the facts out there. This is what we understand the facts to be. If you disagree specifically, then you disagree under oath, because we're putting these facts out there under oath too. And in their world, the Uniform Commercial Code, an unrebutted affidavit, which would be our notice has an affidavit attached to it, so the whole notice becomes an affidavit. So an unrebutted affidavit stands as truth. That's truth in commerce. That's what they live by. That's how international trade happens. And they are always creating contracts by silence, by conduct, which is what we do. You don't necessarily have to get their signature. The notice does two things. It's a notice that you harm me and, you have anything to dispute that with. And it's also an offer to contract. If you agree with me, then we've got an agreement. We've got a contract, and resolving all the matters in controversy between us. So, and we tell them that. We tell them everything up front. There's no hidden messages in there. There's no hidden gotchas. Then the second notice and the third notice are much simpler, but I don't want to jump into all those. I don't know. Do you want to add anything to, the basic notice is the first notice. It's got all the details about the facts of what happened.
Yeah.
And gives them their deadlines for responding.
Yeah, all the facts will be in the first notice, letting them know this is what you did wrong to me in your private corporation. There, you call a court. This is what was done, or when you pulled me over and this happened. This is the harm you caused me. This is how what you did was unlawful. Mm-hmm. You were in violation of your oath. It was unlawful, and you caused me harm. This is how it happened, and it's all explained in the first notice. And then if they don't respond, then we move through with the second notice, and we explain how we gave you 2 weeks or so to respond, and you haven't responded, and we're going to give you, this is a second notice, giving you another opportunity to respond as to how you feel that I'm wrong in claiming, or explain how what you did was right, was lawful, and I'm wrong. Explain that, because if not, I'm accusing you of committing a crime against me, and we'll move forward from there.
And they're invited in the second notice to dispute the facts that they failed to dispute in the first notice. They wouldn't be getting a second notice if they had already responded to the first notice. But they rarely, if ever, do. So they can't really just say, well, I shouldn't be liable because I'm a nice person and I meant well and I was just doing my job. That's not a defense. And it's also not a sufficient response according to what we sent them in the first notice. We tell them in the first notice exactly what to respond to. And if they don't do that, then they're in default. And if they don't understand, that's why we give them a second and a third notice. They can't just say, they can't have legalistic defenses or legalistic responses. There's all kinds of stuff in the first notice that tells them, you can't bring in some attorney. We don't recognize attorneys. If you bring in anybody else to speak on your behalf, we're not going to accept that because probably, for one thing, they don't have firsthand knowledge of the facts. We're only dealing with facts in the first notice. And then we draw conclusions of law later.
Yeah.
But anyway, go ahead.
I think Keith is, we have a Keith here. I don't know if he wants to ask a question. Should I go ahead and bring him on? Keith?
Keith, are you on?
Are you there? Oh, hold on, let me see.
He was there. Is he there?
Hi, Keith.
Yeah, I'm here. Hello.
Hi, Keith. How are you?
Yes. I'm doing all right.
Okay.
Is there any comment you wanted to make? we're just getting into the three notice process, and the first one is the big one, the second one
Right.
gives them a second chance, and then there's a third chance.
Yeah, I'm just kind of listening right now.
Okay.
All right. Thanks, Keith.
Um,
So,
so you'll
yeah.
see how that you can see if you go to our website, you can see the notices. We have right now. I don't think we have any pending notices in our pending notice part of the website, but once you complete all three notices and they're in default 3 times, then you are able to petition our court for an order adopting the agreement,
Mm-hmm.
the contract that we've already established through the three notices.
Right.
And so if you look at the docket and you look at one of the petitions, I don't know. You want to do, which one do you want to do, Luciana?
Whatever you think is easiest.
Okay, how about Constantino versus Desmarteau?
All right.
This is a traffic matter. It started as a traffic matter.
Yeah. I think
If you go to the petition,
and that's on the docket link, on the link to the dockets on our website, and we'll put a link always in the comments after the show to the website, and you can go ahead and click the links in there, and you'll see these in the docket page.
So if you look at Constantino versus Desmarteau, and you click on petition in blue, now you don't petition their fake tribunals. You petition a common law court only, and you only do that after you've already established their liability, which you've established by the three notices.
Yeah.
So then the petition asks, so you've already got a contract with them, and y'all have probably seen this in their tribunals where you have a separation agreement, which is a contract in a divorce situation. And once the people have agreed on a separation agreement, that can be adopted by the so-called court and become a so-called court order. Well, we actually do it with a real court order. So, what the petition, you'll see, scroll down, and it goes on.
Yeah.
And then attached to the petition are the three notices. The completed notices, and you got if you scroll down in Constantino versus Desmarteau, the first notice is dated June 1st, 2021, and it's signed, and it's a copy of the signed notice, and sworn declaration is part of it. Okay, then it has an exhibit, and it's got a couple of exhibits, and it's also got an affidavit of service, is what that was. It's a combination affidavit of service. He did some other stuff there. Yeah. Okay. And then the fax cover sheet. You can have a fax cover sheet or copies of your certificates of mailing, or an affidavit from a man or woman saying, I hand delivered these notices. I sent them through FedEx. I sent them through U.S. Post Office. I sent them through the UPS. I sent them by email. Usually, we don't get into the emailing until the second or third notice.
Yeah.
Well, this is basically the same procedures for serving notices that the de factos themselves use.
Mm-hmm.
So we've never had anybody object that they weren't properly served. Then there's the affidavit of non-reply, and that's done. It should be done by another witness, not the claimant, not the same man or woman who signed the affidavit of service. You've got an affidavit of non-reply. I usually get mail here, and I'm the designated one to receive any responses, and I didn't get any responses from these people to the first notice.
Right.
And then it's the same thing. Then you've got the second notice, the notice of fault, opportunity to cure. We give them a chance to fix it. And same respondents, giving you second chance. And really, it's your second chance to answer the first notice, but you should also require that they give some kind of explanation for why they didn't answer the first time.
Right. And they don't. Like in this situation, not one person did. What we did get was, I think in this case, didn't the law director or something email back acknowledging that they got the notice, but then asking for an email for the court or an address for the court, which was in the notices anyways.
Right. Yeah, I remember that.
Yeah, and so we gave them that again.
So by inquiring, of course, she made it clear, and she was a bar member, that she was acting as their agent. So that was, they can never then say that, they didn't get it. Their agent got it. It's the same thing. When we serve these notices and we put it right on the front page, notice to agent is notice to principal. Notice to principal is notice to agent. If I hire somebody to take care of my yard and they burn leaves or something negligently and they cause a fire to my neighbor, I didn't do it. My agent did it. My agent or contractor did it. And that makes me liable. If my agent gets a notice about the harm he did, it's the same as notice to me. It's called imputed knowledge. If I put him in that position to be an agent, then I'm responsible for what he does. And if I harm someone, then the people who are working for me and part of the operation, they're responsible too. So this is a word to the wise for those who are working for, maybe they're just answering the phone. Maybe they're just, doing internet research. Maybe they're not actively participating in going out and busting heads, for example.
Yeah.
So they can say, well, I wasn't involved in that. No, but you were part of the team. You were part of the effort. You were a fellow agent with the people who did. So, they tried that at Nuremberg and, just doing my job defense, and it doesn't work. It didn't work then, and it's not going to work for them now. And nobody's ever even tried it because they know.
Mm-hmm.
And then you'll see a completed, you scroll way down to the notice of default and imminent liability. That means basically there's no more chances. We've given you 2 chances already. Here's a third one. And after that, and each time you send a notice, you give them less and less time to respond. It's up to you. You're one of the people. You decide how long a response time is reasonable.
Right.
And we do point out in the third notice, this is where we refer to the Bible verse, I believe.
Is that on the third one? Hold on, I'm trying to pull it up.
That's on the third one, I think. It might not.
Second. Is this it? Yeah, third notice is right here.
Mm-hmm. But I'm not finding the, oh, yeah. Paragraph 11, it starts where we explain to them that they were served with the second notice, the notice of fault. And, go to paragraph 10. We review in the third notice, we review what we've already done with them. We gave you a first chance, and then we cite Matthew 18:16, where Jesus tells us in our disputes with our fellow man that you go to the man or woman who harmed you and try and take care of it that way, directly, man to man, woman to woman, whatever. But if that doesn't work, and it's, paragraph 9, excuse me. So in the first notice, Jesus says, if thy brother shall trespass against thee, and trespass means any harm that they do to you, go and tell him his fault between thee, and if he shall hear thee, thou hast gained thy brother. That's the best way to achieve it, but you can't do that by yourself. If they don't, remedy the situation. They don't dispute that you're right on your facts, but they won't usually remedy the situation at that point either. Right. So that means that, and this is also Matthew 18:16. That was Matthew 18:15, 18:16. But if he will not hear thee, then take with thee one or two more, that in the mouth of two or three witnesses every word may be established. So then you bring some other people who are free people, fellow believers, and you remember, all law is based on Scripture. So if he won't hear you, take two or three more that you can establish, what the facts are, what the word, you establish the word. And then if he shall neglect to hear them, you and the two or three others you bring with you, tell it unto the church. And that means really the church always was the forerunner of the court. But if he neglect to hear the church, let him be unto thee as a heathen man and a tax collector. Not much lower status than those things in those times, and maybe still. So they know, and when we quote Scripture to them, they know that they're on the wrong side of it. No, so, and again, with the third notice, and we also have the affidavit of service and the affidavit of non-response.
Correct.
So at that point, the claimant has brought the petition to the common law court, establishing that there are three notices, default on all three notices. The facts are then established because an affidavit that is unrebutted stands as truth.
Correct.
So that we've established what the truth is. none of this filing in their fake tribunals and going through discovery and having all kinds of complicated technical hair splitting motions about was it brought, properly, was it this, was it that, is there an exception, what did the civil rules say? None of that stuff. None of this dragging it out for 3 or 4 years or 10 years or whatever.
And that's anybody who's been through their private corporation court process is well aware, and it's insane, but well aware that you go in there, you file something because someone's harmed you and taken something from you or done something unlawfully, and it takes years. Why does it take years when you've got the clear facts right there to show what has happened? It still always takes years. I mean, because it's a money-making corporation and they want to keep pulling you in for continuances and you need to file this, you need to do that. And it's always years. It's insane that it should take years to find remedy when something has been done so wrong to you.
Well, and the process is really different in their tribunals. In their tribunals, you file a complaint, and I've heard it said, free people lay claim, slaves complain. They whine and complain, and that's how they're treated. And in a complaint, it's generally not. There's not a whole lot of facts. There are some facts, but it's more, I'm harmed this way or that way because of some statute or code, and there's not proof. Now the complaint should be verified, but there's so many. The way the complaint is typically phrased is not something you can dispute one way or the other. That's why it's in a notice of claim. In common law, you put facts in, and we do cite law as well, in a short, hopefully clear-cut manner that they can dispute or not dispute, not something that, well, it's a matter of opinion,
Right.
So that's part of why what the facts are, get out there quickly, and they can be established. And then when facts are not in dispute, which is what happens when they keep defaulting, and they do. And I think they all decided that's what they're going to do, maybe because I don't know why they decide that. They do. And when
I know why. In my two cases that I have up here, because they are absolutely guilty, and in one of the cases here is of a federal crime. It's a federal crime.
A federal offense. They don't have crimes. Only we have crimes. They have offenses.
Right. Yeah. So they have nothing to dispute. They don't have a leg to stand on. I mean, how easy would it be for them to say that I never harmed you. I have every lawful right to do this because of this, because of this, where you're saying that I committed the offense against you. That is not true because this law or this states that we can because of. But the way the notices are written, they don't have a leg to stand on. If you have someone that's really harmed you, like the way I've been harmed and other people have been harmed, and continuing to go into their courts, I think I've experienced it, and almost everybody's experienced it. You go in there and they just keep you coming back. You have facts and evidence in front of them, and what do? They dismiss it. Dismiss. They don't even give you a reason half the time. They just, we're dismissing it. And they know it's not lawful. They know it's not legal. I think they just thought nobody was going to call them out on it.
Well, and their statutes and codes never once mention the terms man or woman. So their statutes and codes, if they try and use those, they can use those in their world, but if they try and use those to defend themselves against our notices, that won't work because we make it clear, you know, my claim is against you as a man or woman. It isn't, and that you violated basic common law and ancient biblical rights, you know, God-given rights. Now,
God-given unalienable rights.
right, and also at the same time, they may have also, and we can put that in, while you were acting as a slave citizen, whatever, for your corporate masters, you also committed offenses in their world too. You know,
Exactly.
those statutory offenses and whatever. That's really all they have. Don't apply to us once we correct our status. We're not their slaves. We're not their persons that they can administer as they would livestock.
Mm-hmm.
And once we establish that, their statutes and codes have no application to us, and they know it because they never use our proper name. They never call us what we are. They have to invent something that they can say they have authority over. And it's all imaginary, though. So.
It's crazy.
Yeah. So that's the 3 notice process, and if they try and intervene with, you know, we can do this, we have the authority to do that. Well, maybe your all capital name, your person that you act for, your office might allow you to do this and this to me, but you as a man or woman are prohibited from it. And I'm only addressing you as a man or woman. I don't care about your other offices.
Right.
And that's clear in the notice. You know, make no mistake, we're addressing you personally.
Mm-hmm. And look,
as a man or woman. You know.
Right. How many times have we seen, and we discussed this before, people that are wrongfully imprisoned, and many times, especially here in Ohio, how many people recently have been released from prison after spending 30, 40 years in prison because it was proven that, and in most and almost all the cases, it's because the prosecutor withheld evidence, which they had 40 years ago in the beginning of the case, which proved that person's innocence. So it was exculpatory evidence, which they withheld from the defense, which they withheld from the jurors. And it took how many years? 40 years. This finally came out, and the person released, and not once do we ever see the prosecutor who did this to that person and took 30, 40 years of their life, never see that prosecutor held accountable. How can that be? How can that be?
Well, every single man or woman, even the violent people who are, and there are violent people locked up in the penitentiaries, less and less all the time because they're releasing them. Why is that? But they're all in. Some people say no one is locked up except because they consented to be, and that seems horrific. What do you mean? That's victim bashing. What do you mean they consented to be? And that's what I'm saying happened because you appear in front of them, you play their game, and you play along with their statutes and codes and their posturing that they are, you know, they have this status or that status, they're a judge, they're a this, they're a that. And you play along with that. You've submitted. You have agreed, okay, you're the decider. I'm just the one that gets decided about. Once you do that, they are free to do whatever they like, and that also means you've agreed to be one of their persons that they can administer, and they can put you into their prison industrial complex and make money off of you from the federal contracts they have.
Right.
So everybody who's in the penitentiary doesn't, nobody who's in there, is there other than because they did not know that the fake tribunal that put them there had no authority to do any of what they did. So, and I don't know if we want to get into it. Basically, we always put the lack of authority in every single one of our first notices. Especially if one of their so-called courts are involved. So if there's and the first reason that they have no authority is they don't have any subject matter jurisdiction. Like, none of the so-called courts that put people in the penitentiary have the slightest bit of authority to do that. Does that mean that people who rape and murder can't be locked up? Of course they can, but we the people are going to have to step up to the plate and be the ones to do it. Right. We're not ready. We may not be ready to do that yet, but there will come a day that we will be, and we will have to be.
Right. Keith was asking here, said, Catherine, can you explain to others why when they send one of their forms out as a response, it's actually not a response, but it's simply one of their forms in their system, not an answer or a response?
I've seen very few responses, if any. I've seen one response, and this was in the, and it's on our website again, in the Franks versus Fothery case, where the clerk, I think after about the second or third notice, sent some kind of little form that said, looks like you're trying to file something in our court.
Oh, yeah, you have to use this form.
Right. That's not a response. That has nothing to do with the response to what we were serving. Right. We don't fill out their forms. We don't go to their courts. We don't dignify them with the titles they've given themselves. We don't do that. And so I don't know what you mean exactly, Keith, about the form responses that they give. I've never seen anything that looked like, even arguably looked like a response to any of our notices ever. I mean, I've only been doing this the last couple of years, but, I've never seen that.
Mm.
Can you clarify, Keith?
Send one of their cancellation forms.
A cancellation form.
One of their forms that they actually sent to me to fill out.
And this was in response to a notice.
Right. Mm.
One of our, like a common law notice?
Right. Mm.
Okay. Right. And it was a cancellation. What did that have to do with responding to your notice?
Oh, it had nothing to do with it. Hmm.
Yeah, I kind of thought that. So,
yeah, it had nothing to do with answering the form or answering the notice, but they just simply wanted me to fill out their form and send it back in.
Yeah, that's what's called. And if you want to scroll onto one of these first notices, Luciana, any of them, yeah.
And that's why I brought it up, because it's not, it's.
They're going to come up with something. It doesn't mean it's a response. Just because it's a piece of paper saying something doesn't make it a response. In fact, we say in the first notice, when we tell them why they don't have any, if these are so-called judges, we tell them why they don't have subject matter jurisdiction. And we also tell them, we define what a sufficient response is. And on Constantina versus Des Marteau that we've been pulling up, you can go.
This one is Frank's versus the Rebecca Frank's petition.
Okay, we'll go back to that. Going to Frank's versus Fothery.
Right.
Going to the petition.
Right.
And going to her first notice.
Mm-hmm. This is the first notice here.
Mm-hmm. There's a petition, and then the first notice is okay. And we tell them what a sufficient response is and what an insufficient response is. And going down to, let's see, page, I'm on 4, trying to see where it is.
Is it page 4?
I don't think it is page 4. I don't think we define. Maybe there's a, well, yeah, item 16, that's on page 5. The part that's underlined.
Mm-hmm.
And we're in that first notice, we call them an addressee rather than a respondent. If any of them dispute any of the above statements, he or she must establish the factual basis for said dispute by affidavit executed by one with actual personal knowledge. And within 2 days, at that time she was in their clutches, and so we didn't want to drag it out very long.
Right.
2 days of receipt. And said affidavit must dispute on a point-for-point basis under penalty of perjury each statement of fact and law herein above stated. So.
And they actually released her after this, right? Was it after the first notice?
It was after. Well, we only gave them 2 days, but we served the second notice about 7 days later, and on the 8th day they released her.
Mm-hmm.
So, I mean, at that time, because she was not able to sign this herself, I did it for her, as you see. And for some people, you're going to have to do that.
Yeah. And if they give you the authority to do that on their behalf,
right,
then it's okay.
Yeah. So, yeah, when they lock people in their dungeons, they oftentimes don't allow very much in the way of access.
Right.
So, yeah, you have quite a bit of experience speaking to people who are locked up in their.
Oh yeah. Unfortunately, I have, yes.
Yeah, well,
and
it involves a collect phone call to you, doesn't it?
No, we have money. We have monies put in their trust accounts if they're in jail or prison, in jail, so that they can make outgoing calls.
Mm-hmm.
When they're allowed to make calls.
Yeah, right.
A lot of times, these jails are in violation, and they either won't let them make a call, sometimes for days. And we hear excuses like people call down there and they get excuses like, well, one of the prisoners was acting up and yelling, so we shut down the phones for the entire jail because that person over there was yelling and being bad. So all the other prisoners now cannot call their lawyers. They cannot call their children for 3 days. They cannot make any phone calls because that one person yelled at a corrections officer.
That's a Nazi technique.
This is what they're doing. And this is also a technique they're using to get these prisoners that they have harmed. They are instead of them harming them, which is what they want to do, really, they will get these prisoners to harm each other, and this is one of the tactics they use.
Yeah.
If
Yeah,
if
that's what
one
it's
if,
for.
yeah, if one of the prisoners shouts or is crying, screaming, "I need my medication! You guys haven't given it for whatever," and starts screaming or banging on the door, they shut the phones off for everybody, the TV's off for everybody, and they do all this, and then all these other prisoners, a lot of them innocent, need to talk to their husbands, or their wives, they need to talk to their children, they need to call their attorney, they need information, they're concerned. And so now all these people in jail are now really pissed off at that person who they see as a person. Now they're looking at that person as, it's your fault this happened. And there are people being injured, beat up in jail, and this is all tactics they use in these jails and prisons. We see it all the time, and it's disgusting. It's disgusting. It really is.
Yeah, it's a technique so that there won't be solidarity among
Yeah.
the people that they're harming.
Right.
Um,
Luckily, in this one case, Franks versus Featherly, I think it was, with the notices, we were able to get her out after a week, and I wish that others had done this three notice process when they were first in the clutches of these evildoers, with these courts or private corporations and their bar mafias and others who act on their behalf. And because I know so many people, if they would have warned the judge, warned the officers, warned them with the notices saying, I'm going after you personally, this is what you did, and done this process, maybe they wouldn't have been in there for 6 months before they got out. Luckily for Rebecca, she was able to get out in 7 days, but a lot of people are held just for months and months with no trial. I mean, in the Lotus Justice case, Monica Justice, she was held almost 3 years without a trial.
And that brings us to, why some people seem like they're using common law process, because Monica Justice knew some common law, but what her fatal mistake was, she was mixing it up in their world, and you cannot cast your pearls before swine and expect a good outcome.
Say that again, Catherine.
You cannot cast your pearls before swine and expect a good outcome.
Exactly.
They don't appreciate it, they don't understand it, and you don't belong there. You don't belong in their swine pen.
Yeah.
Don't go there.
I call it now, after so many years of research and digging and learning, I now call that the devil's den or the devil's sandbox. And
Right.
I choose not to play in their little dirty sandbox, because
there's a mistake that a lot of people have been making, and they follow these so-called common law gurus with regard to the name that's used, that they created, the all capital name, on a few days after your birth, actually, and and when they use that name, they use it to make money. And some people are saying, "Oh, we should be able to access that." You don't even want to go there because how did they make that money? They're trading in these uh, all capital name entities as if they were securities on Wall Street, and which the securities on Wall Street are themselves, fictitious. But all you can see people are treating them as if that's real, and you can invest in this stuff like people used to invest in hog futures or they it's a gambling racket. And do you want to partake of their deeds of iniquity that involve frauds on not just on you by creating the all capital name that they're using, but they're perpetrating frauds on other people when they use your all capital name, um, to steal from others, and they've been doing that for decades. Now, we don't. There's a common law maxim, and that is, you don't administer that which you did not create. Well, our God created us, our parents, through our parents. But our all capital name was created by them. We don't administer that.
Correct.
We didn't create it. We don't administer it. We don't partake in the spoils of what they do with that all capital name.
Right.
People have told me, "Oh, but you're leaving money on the table."
Yeah, I just heard that someone called me yesterday, said they were going to be filing something, and they said, yeah, I talked to a couple people, and they told me, yeah, don't correct my status because once I do, then I can't lay claim to all the money that they've made off of my all caps name by using it here,
It's
using it
not
there.
their all capital name. They didn't create it. It's not theirs. It looks like their name, but it isn't theirs to do with as they choose.
Right. And I forget what is the name of that case, Catherine, where even though you pull yourself out of the system, you as a person can choose when you want to
As a man or woman, yeah.
right, when you, and there was a case, I forgot what the name of the case was. That
Where you can be because we sign our name a bunch of different places, and continue to do so. We continue to administer the all capital names when we really have to to get a bank account, to get a job, to to get a driver's license. You really don't. You don't have to get a driver's license, but some people, still they've corrected their status in the three ways we talked about earlier, but they won't correct their status as to the driver's license, which we're not required to have anyway, because there's so many weaponized, code enforcers on the road, and their corporate uniforms with sporting their shiny badges that will beat you up, destroy your automobile, and do all kinds of stuff to you if you don't have that. But I'm finding actually little by little that there's been enough YouTube videos maybe that show people standing up for their rights in a traffic stop. Most people don't really understand their rights, but if you really do, and that there's different levels of understanding, and if you get to a point where you really understand what your rights are, your right to travel, which they recognize your right to travel from point A to point B, they can't interfere with that. Well, what is a driver's license except a form of interference with your right to travel? And also, a license, by definition, like a permission slip to do that which would otherwise be unlawful. Is it unlawful to travel from point A to point B? Not at all. It's a common right that they, the de factos recognize that in their decisions. So
like the license to fish. That one
yeah,
still shocks me to today. A license to fish.
right. And it's not like, I mean, how would they have any authority to run a licensing operation anyway when they don't own those fish, do they? I don't think they do.
They
Do they create those fish? I don't think so.
they unlawfully make themselves owners, it seems, of everything.
Well, but that's just
And
a psychotic delusion. That's not
of
reality.
course it is. Of course it is. But they write it down in the little codes. They write it down in the little codes, so it must be true. Must be, because they wrote it. They wrote it in there.
They do. There is a method to their madness in some ways. They won't actually come right out and say, we personally own these fish. They won't say that. They will just kind of skip over the ownership part and just say, and they do this with property tax too. There's nothing in there about how they have the right or where they get the right to impose property tax on people's land. But they just go into great detail about how they're going to do it and what the procedures are. They're good on the procedures, and what the punishments are if you don't do what they say, and all that. And they skip over, how did you get the right to do any of this stuff to begin with?
And we, the people, don't question them on it.
And we don't question them.
That's
exactly.
The problem here.
Exactly.
And we don't question them on it. And so because we don't question them on it, they feel we have consented to what they have proposed and put out there in their little code book and the little administrative laws and codes and statutes. Well, they're letting us do it, so let's do it, right? Let's do it. More money for us.
We're going to be doing, and this is especially for people in Ohio, but people anywhere could do this. If I would get some practice doing some other things for anybody who wants to form a common law court in your state. I would say that you want to, one of the first items of business and the next item on our agenda is to have a multi-claimant action, a multi-claimant claim against the various people who are administering these corporations that are interfering with our right to travel in all kinds of ways, through licensing of the right to travel, through attacking our right to operate our automobiles and trucks. There's another branch of their corporate structure that deals with that, known as BMV, Bureau of Motor Vehicles. That's a whole criminal operation in and of itself.
No, Keith just said in the marriage license.
Yeah, right. That doesn't. Marriage license is another one. Let me address that after I do just go through the things we're afflicted with on the roadway that make road travel so hazardous for people. Then there's we've addressed the driver's license situation. I guess that's pretty much the high point, but and that they have no right to administer a driver's license procedure unless we just agree to it. Now, the marriage license, when you this didn't come in until the corporations masquerading as government started kicking into high gear in, I think it was sometime in the 1800s. And um, you had to get permission from your slave master corporation to get married. And that permission came in the form of a marriage license. And you had to fill out applications for that. And you had to pay fees for that. And, or you thought you did. They told you did. They threatened you. If you don't do this and you get married anyway, then, you could be accused of, I don't know, bigamy or something if you were, I don't know. They had various crimes.
Yeah. Or if one of you passes away, the other person gets nothing, and we, the state, will take everything because we said you were not married because you didn't apply for a license and pay us fees and come to us for permission. When this is really sick, because marriage is between a man and a woman and God. Mm-hmm. And the corporation, your state has, or your county has taken over, or they have given you the illusion that they've taken over your right to marry, and that you must pay them and ask them for permission to marry, and then they will give you a piece of paper saying you're married. And if you don't do it that way, pretty much what they're saying is, screw you guys and screw what God says. We say you're not married. And if your spouse dies, we don't consider them a spouse because you didn't pay us our fees. So we get to take everything. You get nothing, even though you consider yourself their spouse. And they've done this. And we know some people right now that are still fighting. I think somebody told me 5 years fighting with, I think it was Allie. It's been, I think it's on this particular situation, or she's got a couple situations going on with them taking, I think it's her mother.
Can I post the diagram of the marriage contract on the right here? I wanted people to see this because apparently.
Where?
Over on the right in the comment section, anywhere where people can see it.
What are we looking for?
I found it already. I have an image of the marriage contract that's actually taken from their records that shows what they think a marriage is.
If you send it to me right now,
I'll send it to you.
To my send it to my Yahoo. I can open that right here.
All right.
And then I can pull it up.
Okay. Let me do that.
There's just so much that has been done, and for so long, that people have not questioned. People have not fought against it. They've just given up their rights and figured, oh, well, they say we need a license for this now. Oh, they say that plant, that God-given plant, is illegal now, and if we want to grow that plant, then they're going to kidnap us and abuse us, and we'll have to fight for years in their court because they said this plant is unlawful. So it's really sad.
If they say something is, doesn't fit with their rules, they'll call it illegal, and sometimes they mischaracterize it as unlawful. But unlawful is really if it violates common law. We don't care. Something can be lawful but not legal, and it can be legal but not lawful, and that happens a lot. I sent you the diagram. Did you get it?
Is that it?
Yes.
Is that yes. Okay.
Yes. And you can see what they've done. And I think I don't know. I think I got this through somebody else as far as this being an actual document that one of the federal three-letter agencies has, and they keep this in their records because they're always recording, you know, who we are and, you know, what our associations are and, you know, when they administer Social Security and so forth. And they just can see where I don't know if you can tell it very well, but there's a solid line between husband and state and between wife and state. And there is in the bond between husband and wife, I believe, it's either lighter or it's dashed. It's in dashes. And then that bond is attached weekly, you know, through a dashed line to God. So what they want to kick God out of the equation, and they want to make the marriage contract something that they can administer, and that means we can administer your all marital property. So you're going into their fake corporate so-called divorce courts, family courts, and they claim, well, when you applied for the marriage license, you gave us authority to administer marital property, including biological marital property. So that's how you surrender your right to deal with your own children. But you don't have to do that once you rebut the presumptions that they created for when you applied for the marriage license. We don't even call it marriage in common law. We call it a covenant of matrimony under God. They might run the marriage license racket, but God operates the covenants of matrimony between men and women under God.
Right, which these private
and they
corporations
seem to know this. They do seem to know this. If this is indeed from their records, and I think it is. So once you kick them out, you say, well, wait a minute, this contract here, we didn't enter into that. We entered into the one between husband and wife under God. And you don't have any authority. See, there's no connection between God and state. None.
Yeah.
And they know that. So.
Sad, very sad.
Yeah. That is another, reason the so-called family courts aren't courts. They can't administer. They can't, without having committed fraud first, they can't administer marital property. Now, people get coerced into agreeing anyway. It's not really an agreement, but if it's coerced, it's not an agreement. So you can do that. You can agree with your spouse to end the marriage. Marriages, like other covenants, can be induced by fraud. They can be. There's various reasons that they can be terminated lawfully, and even biblically. I think during Moses' time there was such a thing as divorce. So God recognizes that people should not be required to live in intolerable situations. But I don't think it should be just on a whim either.
No, I think it's if the spouse has been unfaithful, right?
Yeah.
Yeah, you're not expected to stay.
Or your life is in jeopardy by staying with the spouse.
Right.
Yeah. Well, I don't know. Okay, we had a comment about consistent with Matthew 18, and that would be, I think that's the 3-notice process that we were talking about.
Right.
Yeah. Okay, so that's and also in their world, they have admitted that we are the source of all law. So whatever structures we make, you know, that's lawful. You know,
And that God's law reigns supreme.
right, right.
You know,
Mhm.
Keith had asked, the Ohio Supreme Court almost never gives a reason to not take a case. They simply either do nothing or they just don't take the case. They just decide if they're going to take it or not.
Oh yeah, yeah.
And most of the time when they dismiss a case, once they do take it and they dismiss it, they don't give a reason why it's being dismissed. Very strange.
Mhm. Well, I mean, what the real? I guess they're tired of making up reasons because the real reason they do anything is the same reason that any corporate agent acts the way they do. It's to make a profit for the corporation. That's the purpose of the corporation. It always is.
Right.
Or not the purpose of the corporation, the purpose of the people running it. But since the corporation really doesn't exist, it's just corporation is a mental excuse. It's an excuse that they hide behind to commit whatever, acts of thievery or kidnapping or murder they choose to commit. So I don't know. I feel like I'm running out of steam a little bit. I don't know about
Yeah.
you or any
Yeah.
issues we want to bring up. We've been going for close to an hour and a half
Correct.
now,
Right. Yeah. Me
and
too.
and so and maybe a good portion of the people who may see this broadcast are going to be um, uh, going to be commenting later. Okay, we got a comment that just came up. Could the kidnapping of the children be regarded as coercion? Um,
Just to participate in services.
To participate in services. Which kidnapping of the children are you talking about? When the children are kidnapped? I mean, there's a number of avenues that they use to kidnap children. Sometimes in family court, sometimes in juvenile court, sometimes
Right.
they traffic them through the foster care system. Sometimes they
So
send
many
them
ways. They've
to
removed they've removed children, and the state of Ohio and other states have taken it upon themselves and said that they have the right to remove that child from from a good parent because the parent decided to homeschool
oh, that,
and
yeah,
has
I don't like that.
and has said the state now has custody of this child.
The state can't have custody of anybody or anything. The state can't do anything. But the people, so that's why those terms are important, because the people who are operating the so-called state that doesn't exist, do they have any claim to that child? Does that social worker have any claim to that child? Did she birth that child? I don't think so.
And that's why I mean I find it very important for people to understand this 3 notice process, because when the state says, oh, that's it, we're terminating your custody, and now the state has uh, custody of your child, we're going to put him in foster care, he's got to do this, and this, we're going to inject him with this vaccine, we're going to make sure he does this. And the parent, I mean, the 3 notice process will notify them, you had no right to do that, you are harming me, you are harming my child, these are the crimes you're committing, and assaults on me and my family, and do the affidavits, and see if they respond. Because other than that, you're just, I mean, you can file objections, you can file motions, and almost always it's years and years and years before you get your child back, if you ever get your child back.
All right, here's a comment that maybe clarifies some of the earlier ones. Remove kids upon false allegations of abuse and neglect. Well, by juvenile court. A so-called court, which is not a court, cannot make allegations. What are they going to do? They don't exist. How can they make allegations? People can make allegations. And so you have to look at who, and they better make those allegations under oath. So you have to see who are the people who made those allegations. It'd be easier, Michael, Jennifer Babson, to make it clear, was there any affidavit from a person, from a man or woman, with actual knowledge that the abuse occurred, and what did it consist of? When did it happen? And if they don't have that, then, I don't believe that you should be able to, beat your kids to death. I think that's something that we, the people, could do something about through common law grand juries and in other ways. But you have to have more than just you have to have more, and I've seen this, and I hate to hear this. I brought you in this world, I can take you out. No. But the corporate state certainly can't. So you have to see what are the allegations? Are they backed up by an affidavit by someone who has personal knowledge? And they never do. A juvenile court, first of all, doesn't exist. A juvenile court is a corporation. It can't sign an affidavit. It doesn't exist. A social worker probably was not there when any abuse happened or is even alleged to have happened. So the social worker can't say anything. Who's going to say something? Well, oftentimes, like in family court, they might have the other parent, or the other parent may on his or her own make an allegation, I was there on such and such a date and this happened and, I swear to it. Then you have an actual dispute of fact. It didn't happen. Okay, here we've got, so there was no affidavit. If there was no affidavit, no sworn declaration that any abuse happened at all, you can't just skip over that part and jump right into the abduction of the children. No, you cannot do that. The only way you can take children from their parents is if there's established as a fact, not just an allegation, but as a fact that abuse occurred. And sometimes an abuse allegation might be under oath and be perjured. That could happen. And we don't really see that much. We see no allegations. So if that were to happen, though, if we had an actual dispute, and we've never seen it, but if we ever did, then we could resolve that dispute. The people, the ordinary people, could resolve that dispute. Did the abuse on, January 13th, 2000 and whatever, did it happen? Did the mother or father, hit this kid in the head with a brick or not? Did that happen or not? And then you can bring in the people who were there at the time on that date, and you can bring in what you want to dispute that. But that's not what we're dealing with. We're dealing with, there's no allegations that are backed up with any affidavit.
Right.
So if you can't back it up with an affidavit, it must not have been true. So you can't go any further.
Yeah. Catherine, can I just play like 1 minute from the Pasadena, California case of Hardwick versus Vreeken for them to hear? And this is even a judge stating you can't come in here and with lies in order to steal custody away from a parent. And in this case, these were parents that I think they had a situation maybe with drug abuse, and they straightened everything out and they got cleaned up and wanted their children back. But CPS was using lies and the tactics that they use, and the lower courts just believed what they said and terminated these parents' rights. I think but let me just play. I think that in this one part, this judge did the right thing, and what he says in this short clip. Hold on. Okay, can you wait?
I see
Okay, all right, hold on. Let me see if you can hear it.
It's not been clearly established in the year 2000 when this removal occurred was the idea that the right to be free from deliberately fabricated evidence in civil child abuse proceedings that result in the deprivation of a protected liberty interest, the same liberty interest that's at issue.
But it's not the same liberty interest because this was a parental liberty interest.
It's a biological versus foster parent.
That's huge. That's gigantic in terms of what somebody could appreciate and understand. How in the world could a person in the position of, we have to take the facts as they're pleaded in the light most favorable. So, we're not trying the case. But how could a person in the shoes of your clients possibly believe that it was appropriate to use perjury and false evidence in order to impair somebody's liberty interest in the continued care, custody, and control of that person's children? How could they possibly not be on notice that you can't do that?
I understand
how could that possibly be?
I understand the argument that it seems to be common sense and our ethical.
It's more than common sense. It's statutes that prohibit perjury and submission of false evidence in court cases.
State statutes.
Are you telling me that a person in your client's shoes couldn't understand you can't commit perjury in a court proceeding in order to take somebody's children away?
Of course not, Your Honor.
Of course not.
Then isn't the case over then?
And the case is over.
I think that speaks volumes right there. But it happens every day. It happens every day. And people's children are taken away.
Right, and the thing is, whether the testimony, I assume it was testimony. I assume that the attorney at the lectern was representing a CPS worker, probably.
Yeah.
Why was her testimony allowed in there anyway? She probably had no firsthand knowledge of anything, much less to dicker about whether it was true or false, or whether she made it up. She's an outsider. She's not a fact witness.
Correct.
So I don't. It looked like this was an appeal proceeding. Maybe not, but it sure looks that way. And then of course that tribunal is corporate anyway, so they don't have any right to be dickering over this to begin with. And none of the people involved have any authority. They're all bar members, and bar members. Let's just get that out right now. The participation of bar members, because they take their instructions from the so-called ethics codes, the international bar guilds, and European bar guilds, and the fact that they don't have any firsthand knowledge of anything. Why? But yet they're testifying. I remember I used to. I saw some other attorneys do this, where they would say, "Look, if counsel's going to testify, he needs to get up on the witness stand and be sworn in and give us an account of how he comes by this information.
Right. And
He
what's that word when you can actually pull, if the prosecutors make a statement, you can actually ask them to go in and get sworn in because they're making statements.
You just call
And
him
in order to do that, what is that word for that?
You just call him as a witness.
I know. Yeah, there was a word
You
for
can
that.
call him as on cross-examination because he's a hostile witness, and this is all in their world, you know. But he has no business being a witness whatsoever. He can be a witness as to the procedures that they subjected somebody to. If he personally was involved in subjecting that man or woman to these procedures, he can testify about that, of his own personal knowledge. But he doesn't have any personal knowledge of what goes on in people's households. I don't think, unless they're his neighbors or something, friends he used to visit. But no, they don't have a role. Okay, and the other reason they don't have a role, and this was in the early part of the formation of this country, the intention was clear that from the original 13th article, and I think did we post this the first time, the 13th Amendment to the original Articles of Confederation. That was the original 1781 Constitution. It was ratified in 1781. It was they call it the Articles of Confederation, but it's still with us. It's never been repealed, and they went on to enact other constitutions after that. But that was our original one, and that got amended. It had 12 articles, and then there was a 13th one, or 13th Amendment, and in that 13th Amendment was very unpopular because a lot of the founding fathers and their buddies were bar members, and they wanted to have a strong voice in government, but bar membership carried a title with it called Esquire, just beneath the rank of knighthood. It's what was considered an emolument from a foreign power. And people who take emoluments from foreign powers, whether it be the Vatican or Israel or the UK, they can't serve in positions of public trust. And that's what happened. The founding fathers, and well, not so much them, but I think it was more a group of people, wanted to make sure that they were not going to have their new country run by puppets from Mother England. Maybe we didn't post. I thought we did post it in the comment section of our last broadcast, the original 13th Amendment, and I'm just finding the file. And it says, maybe we can close with this, unless somebody wants to ask something else. And this could be huge if we made an issue of it, and I think we should. I make an issue of it in all of our notices, and they never dispute it. So there should be no dispute now. If any citizen of the United States, and at that time United States meant the country. Today United States means the corporation. If any, and citizen actually, this was before the 14th Amendment, citizen actually meant one of the people. If anyone shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind whatsoever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. So you can't be a public officer in a state or in the federal republic. And that was ratified by 2/3 of the states as required, 3/4 of the states as required. There was some question about whether Connecticut ratified, but they found evidence of it being ratified in 1824. Ohio ratified January 31st, 1811.
Mm.
And yet, the so-called governor, well, he's the only governor of the state of Ohio, is one of these citizens that are prohibited from being citizens.
From holding public office?
Yep. He has no business being in there. Neither do 80% of people who are holding office in the general assemblies of the states, Congress, House of Representatives, Senate, any of that.
And
being there.
Yeah, and when all this was done, all this was created, they put their people in positions of power that were lawfully really not supposed to be there. And it has gone on for so long. The fact that for so long and so many decades and centuries, just nobody, they just allowed the people, allowed this to happen, allowed it to continue, decided, I suppose, that those people are their masters and decided to be slaves and not say anything about it. It just continued and it just grew and it just festered and now here we are. And
Right.
people, so many, refuse to believe that this is really what's going on.
And remember, public office means a judgeship too. So, and they made sure that every single so-called judge would be a bar member. So we can safely say none of your judgments are valid. None of them, if they come from one of these corporate tribunals.
And the fight to get this all corrected is so tremendously huge because, again, they will pull every single actor that they have working on their behalf, police, sheriffs, FBI, see everybody to fight against this, because imagine all the cases that would need to be vacated because they were unlawfully decided. And think about that.
Right. Yeah, none of these are valid decisions. Yeah. So doesn't mean that we're going to have anarchy. The people can still govern, and they're the ones that should. We don't need CPS. We don't need their fake corporate tribunals. We can do this ourselves and do a heck of a lot better job than what we've seen.
Oh my gosh, for real.
And I think it's everybody's responsibility to step up and do that. A lot of people you hear, I don't want to serve on jury duty. Well, of course, that's jury duty in their fake system is something else. But I think we all have an obligation. If we want to live in a free country, then we have the obligation to govern it ourselves. Yeah, we could delegate it, and maybe we're going to have to delegate some of it. But I don't think that's the direction we ought to be taking. But anyway, I'm getting too far ahead of what people right now in their communities can do.
All right. So I guess we'll be ending this podcast, and I thank everybody who's listening or going to be watching later on. And if you have any questions or any comments, like you don't understand this, or you think we're nuts, how on earth do we think we're going to get away with this? We'll be happy to comment back and show you what we got.
Right.
which is a lot more than they're doing
Yep.
by staying silent and doing nothing.
Right.
Nothing. They just assume we gave ourselves the right to be your master, and we know we got this huge police mafia backing us up. So we don't need to answer to you because we're above the law. Who are you, you little slave? That's pretty much what they're saying to you. I mean, you have a right to give someone a notice, a judge, a police officer, a prosecutor, and say, "You did this. I'm notifying you that you did this, and I'm going to hold you, the person, accountable for what you have done to me." And their attitude is, "Oh, but we're above the law. We don't need to respond to you, you little peasant." That's their.
I don't know.
This
They
is
don't
what
say
they
that.
think it would
They,
be.
that,
Of
that,
course they
that,
don't. Of course they don't say it. This is what they're obviously
well,
what they think. It's
I don't know.
disgusting.
I don't know what they think. They don't talk to me.
Yeah, they don't respond to any of this.
Right.
They're
But
too good. They're too good to do that. Please.
right. Okay. Well, we can talk about how it works, why it works, the fact it does work. We have made it work. Why sometimes the common law 3 notice process doesn't work. The mistakes people commonly make in trying to use it, and we can do that next time, which will be in a week from today.
That's right. We'll see you guys. We will see everyone next Thursday at 8:00.
Yeah, that'll be the 18th. The 18th of May.
Right.
Right. Okay.
All right. God bless you all, and everybody have a great night.
Thanks, Luciana. Good night.